Yet another eye-opening dialogue to share with you in regards to the information that you need to know about things happening right here in the community. So sit back, relax, and enjoy the next 30 minutes of hard-hitting facts, informative insight into the process of wills and estates on this edition of The Will with me, Belinda Conaway.
You know, I still cannot believe that Prince is gone.
I know, right? And he was so young. He died without a will.
Really? I didn't know that. I think I need to get a will.
I think you're right.
Let's not make the same mistake. Write your will today. Call us, visit us online, or check us out on social media. And remember, where there's a will, there's a way.
Welcome back to The Will. I'm your host, Belinda Conaway, your Register of Wills for Baltimore City. And today, we have two great employees who will help convey the intricacies of the probate process, which is the process of opening an estate for a loved one who has passed away. They will help break down the differences between a small estate and a regular estate, the fees that go into opening these estates, as well as the information you're going to need in order to open an estate in our offices. To my right is Deputy Larry Edmond. Mr. Edmond is the supervisor of the probate department and helps to ensure that you are serviced in a respectable and timely fashion. He's been with the Register of Wills for several years now and is versed in estate law and the process of estates like none other. Welcome to the show, Mr. Edmond.
Thank you.
And to my left is Deputy Cynthia Blackwell, who is the supervisor of the audit department, which is tasked with handling the regular estates and finances in relation to larger estates. Thank you for joining us today, Ms. Blackwell.
Thank you for having me.
Today, we will discuss an overview of the probate process from the functions of both the probate department as well as the audit department. So stay tuned, and we'll be right back after this break. Trust me, you don't want to miss this important information.
I'm Belinda Conaway, your Register of Wills for Baltimore City. Be sure to write your will today and register it for safekeeping with my office. For more information, call 410-752-5131. And remember, where there's a will, there is a way.
Welcome back to The Will with Belinda Conaway. So let's get started understanding the probate process of Roe. Mr. Edmond, you're tasked with overseeing the probate department. Briefly explain to the viewers the general overview of your department and the difference between a small estate and a regular estate.
When an individual comes into the office, my preference would be to have them to call first. That number would be 410-752-5131. And if you want to get in direct contact with me, my extension is 320. Things that we ask, which is more important for you to basically navigate through the process, is one is that we want to know, is the individual a resident of Baltimore City? Second, is there a will? Once we go through those two particular things, we then try and figure out what the assets are. We start off, does the individual own a house? If there's a house, is the house paid off? If not, we would need to know information in reference to what's the outstanding obligation on it, whether there's a vehicle, whether there are stocks, bonds, whether the individual has a bank account. Once we go through those menageries of talking about those things, then we make a determination whether you have a small estate or regular estate. Currently, the limit for a small estate is $50,000. And anything over that is a regular estate. There are several things that goes into an individual bringing in, whether they need a bond, whether we need to do publication. The purpose of the publication is, one is for creditors. They are family allowances, i.e. if there's a spouse, if they are minor children, then basically that's also an allowance. Those allowances are basically derived for the purpose of allowing the individuals to have additional income as opposed to creditors absorbing all that income. So those are the things that we do. Now, if it ends up being a regular estate, a lot of times you would have to possibly get waiver of bond from the immediate family members. Those are forms that you can get from the Register of Wills Maryland website. To make it easy for a lot of people, we just tell you if you want to go to the site, go to the Register of Wills Maryland. You can look on the forms. You can download the forms for the small estate as well as the regular estate. If by chance, if you have difficulties as far as navigating through that process, then by all means you can give us a call, and we'd be more than happy to help you to fill out those forms, where we do them on site as well as on the phone. One of the things that we want to do is that we want to minimize the number of times that you visit us. If by chance, if you're down there for 3 times, we haven't done our job. Because if you call, we give you the information. When you come to us, if you don't have all the information, then what we do is that we give you a checklist. That checklist entails all the things that you would need to do in order to open up an estate. It entails the forms, who needs to sign, and basically what you need to bring back. One of the most important things also is there's a cost associated with that. That cost entails basically, if it's a small estate, the max that you would pay would be $150. You will have to run notice at a cost of $49, and we will notify the heirs at a cost of $526 by certified mail. Therefore, they have a time frame where if they would like to object to the individual that was appointed as a personal representative, they have that knowledge and they can actually file papers with our judicial department.
Okay, that's a lot of information.
A lot of information.
Okay, so we talk about a small estate, which is under $50,000.
Correct.
That does not require a bond.
It is predicated on the allowances and the amount of money. Okay. So take, for example, the allowances are $15,000. If we come in, the estate's value is at $30,000. Based on the threshold being over 10 after we subtract that amount of money, then the law requires us to have a bond for that individual.
Okay, so for people who don't know what a bond is, would you explain to them what that is?
A bond basically protects the interests of the heirs, i.e. if I've never handled money properly and for some reason I come down and get appointed, because there's no reason why any person can't get appointed if they're in the same class. They've changed the law where you now have a spouse and the children are in the same class. So if the child comes down, we will open up that estate providing they have all the things that they need. Now, we will protect the interests of the other heirs, because if the threshold is over to $10,000, we're required by law to have a bond. That bond protects them dollar value, dollar for dollar. So if there's misappropriation, you can always go against the bond to basically receive your inheritance or whatever portion of the estate that you're entitled to.
Okay, so if the personal representative does not do what they're supposed to do, let's say there's a bank account and the funds are not distributed the way that they're supposed to be, that would be the purpose of the bond.
That's correct.
The bond insures the assets so that anything that's misappropriated insured.
That's correct. And what they can do at that point, if for some reason they don't receive the assets that they're supposed to be distributed, they can always file on the judicial side with the court. And at that point, they file a petition, request for distribution. If the court finds that the money has been misappropriated, then at that point, the judge can order the bond to be what they call condemned. And at that point, they can go through the process of being paid based on their portion, whether it's $5,000, $10,000, or whatever portion it is, divided by the number of heirs.
Very interesting. Thank you for sharing that with us. Mrs. Blackwell, please explain to the viewers about the audit department and the information they should understand about this important office.
The audit department is actually the last step of the probate process. We ensure that the distribution is made by either the law of intestacy, which means the laws of the state of Maryland, or by the will. One of the biggest misconceptions that our personal representatives or the heirs have is that once the person passes away, their debts are done. That's not true. Claims can be filed against the estate, and we ensure that those claimants are paid before the estate is considered closed. We make sure that all of the probated assets, and probated asset means anything that is in the decedent's name alone, is inventoried on our inventory department, and then we make sure that all of the allowable expenses are shown on the account and that the heirs receive their full distribution. We are also responsible for collecting all of the administrative fees and any inheritance taxes due. Now, at this time, children, spouses, mothers and fathers, sisters and brothers are exempt from inheritance taxes. However, we have to make sure that those collateral heirs, which means These are the people that owe us taxes, that we can receive our taxes.
Well, you look very serious about that.
Very serious. We want to get our money.
So you're the person that goes back and makes sure that everything it was distributed the way it's supposed to, and that all money and all assets are accounted for.
All money and all assets are accounted for, and all taxes and all fees are paid.
Okay, all right, that's great information. Mr. Edmond, what do you commonly find that people forget to bring in or don't have when they come to office to open an estate?
Most of the time they won't have the death certificate. Or if there's a will, a lot of times they don't know what a will is. As a hindsight, we maintain wills for the city of Baltimore, and a cost is $5. It's not imperative that you deposit those wills with us. However, we can guarantee they are safe. And we've never lost a will in my 17 years, and I think Ms. Blackwell's been there a lot longer than I, and we've never ran into a problem where we've lost a will. My only concern is that you make sure that you know who the personal representative is aware of where your will is. So that's the basic things that we need to know. One is that if it's at home, based upon you going through the process of trying to find out what the person's assets are, sometimes you have an heir that would take it. They know there's a will. And at that point, if we can't get the original, then we have a problem. We can't probate something that we don't have. So that way you're assured that your wishes are taken care of, because one is that we have complete control of that will. And we will not give up that will unless the individuals themselves come down, send a letter with identification requesting that it be removed, or it's going to be removed at the time of their death and put in what we call a will and no estate.
So, for example, a person has 3 children, and they decide to put 2 children in the will, but not the 3rd child. So you're saying that sometimes, depending on who the first person is to get the will, if someone doesn't necessarily like what's in the will, something may happen to it between the time it is found and it gets thrown out.
That's correct. And that's why it's important, if you want to store it with us, it's safe. At the same time, we will only appoint the person that's named in the will unless they decide that they don't want to serve. At that point, most of the times, the individual will name a second person as far as being the executor. So we have to get consent from that individual, and then the second person can move forward. If both individuals decide that they don't want to serve, then anybody else that's listed in the will has the ability to serve as personal representative. The only difference is that in the will, they exempt the person from bond in most instances. If I'm the 3rd person and I'm not appointed, then we act as though there's no will for that individual, but we still adhere to what the will says. So we require that person to either get consent from everybody as far as the waiver of bond, because we're going to protect the interests of the heirs, and they are bound by the same duties as the person that was named in the will.
Well, when you say waiver of bond, that means that if the 3 of us are heirs, then all 3 of us would have to agree to say it's okay for you
That's
to
correct.
be the personal representative.
Well,
So that's what we're talking about when
Correct.
we're saying a waiver of bond, that the parties come together and agree that this person, it's okay for them to take care of the business.
That's correct.
Okay.
Now, if for some reason if you don't believe that this person is going to act accordingly the way that the law entails, then at that point it behooves you to basically not waiver that bond. Because in instances, if you're all in the same class, I can't delineate to appoint the oldest, the youngest, or the one that's in between. It's whoever gets there if there's no will. But I will protect your interests based on what the law says.
Okay, Mrs. Blackwell mentioned that earlier. You talked about someone being intestate or there being a will. So you want to explain to the viewers intestate?
Intestate means actually that there is no will. So then you have to make distribution according to the laws of Maryland, which if they're children, then they have to have equal shares. If there's a spouse and children, then the spouse receives what is called a spousal allowance, which is $10,000. And then they have a spousal exemption, which is the first $15,000 and 1/2 of the estate. And then the children will divide the remaining half. That's the laws of intestacy. Now that's going to increase and I think it's in September, where the spouse is going to receive the spousal allowance, which is a living expense, and then the first $40,000 and one half of the remaining estate, and the children will divide the remaining half. If there are sisters and brothers, they share equally. If there's parents, the parents share, and then if there's just a mother, then that sole parent would receive all of the inheritance.
Okay, and you talked about a spousal allowance. How does that work if someone is separated? Does that
As
matter?
long as they're not divorced.
So as long as the people are legally
As long as they're
married,
legally married.
then they legally have a right to a portion of the estate.
Right. However, if the spouse is left out of the will, they can elect to get their spousal share, which means they are automatically file with our office their election for their spousal allowance, and then once the distribution is made, they get 1/3.
And one of the things that we encourage people to do is to keep important paperwork together where someone can find it if something happens to you. And certainly if there are divorce records, marriage records, or anything like that, that may be pertinent, you would want to add that to your list of important papers because it may be needed. Interesting, very interesting.
May I add, when we talk about important papers, a lot of times the individual gets divorced. If they have real property, if there's no indication as far as what happened with that property during the time of the divorce, then it's actually severed into what we call tenants in common. So it's very important for them to have those documentation because it could be 15 or 20 years and you haven't done anything with the property and you come down, you assume that it belongs to the individual when in actuality they only have half. So now you got to worry about it.
What you're saying is that when you say they haven't done anything with the property, so a couple owns a piece of maybe vacation property on the Eastern Shore.
Correct.
And they are divorced. Two names on the deed for the property, and they never change it for whatever reason. The two names, and that's tenants in common.
That becomes tenants in common.
Okay,
Yes.
and so that's what people need to understand. These are important documents as well. Anything that has to do with your property, land that you own, any changes for the deed. So if someone does not get that paper, husband and wife divorce, but they never do anything with the title to have the information changed or to say, well, you know, I'm going to give it to you, or you're going to give it to me, whatever's going to happen. What happens? There are two names on there, one person dies, they're no longer married.
Correct. At that point, the deceased owns half the assets. Now, with you owning half of the assets, you can't sell that house unless I get the other person to sign off on it, because the deceased only owns one half of it. So we will probate that one half based upon the value at the time of the individual's death. Okay. And a lot of times they will come down thinking, okay, it goes to mom or it goes to dad, when in actuality, if dad's deceased now also, so now you got a separate group of family members, particularly if it's a blended family. So now these children are not the children of the father because he has additional heirs. So now you got two families with two halves of a piece of property.
I can imagine it gets very interesting.
It's very interesting.
And I think another thing people need to understand is that if there is a deed and someone is deeded the piece of property, and then that person draws up a will and states that another person is to receive that property, the deed is the most important document. So that property is going to go to the person who is deeded to, not the person who is willed to. It's the deed supersedes the will, which means the deed is the more valid document.
And another important point we want to add also is that a lot of times they look at it and say, well, the will left the property to me. That may be the case, but there's a process in order for you to get that property. It just doesn't come to you based on the will. You have to open up an estate. You have to go through the process, whether it's a small estate, a regular estate. This black will do basically the distribution and say what portion and who gets what. And she can probably expand on that a lot. Whereas if there are debts, how those debts are paid if there's no money.
I want to just go back for a minute to make sure that people understand. You mentioned if there is a property, I believe it's called a life estate, where someone has, on the deed for the property, someone has already designated, I want this property to go to.
But with a life estate, that doesn't become a part of the probated process.
As far as important papers, we know that the will is good to bring it down for safekeeping with the Register of Wills office. That costs you $5. Important papers that we need to keep together, I would think a copy of the will should be kept with those important papers. Any deeds that you have, as well as any divorce papers or marriage documents that you have that would assist whoever has to carry out the business of your estate.
Correct.
Okay, as well as bank statements.
Bank statements.
There's been an issue because a lot of us now have online accounts and everything is paperless. So that makes it a little bit challenging when people have to find out what your assets actually are.
Right.
Because some of those things you don't receive statements in the mail, and once you pass, the person may not have access to your internet site or your personal email account in order to get this information.
So what we do in that instance is that we do what we call a limited order. Normally you would come to us, the estate's not open up, but you'll come with the death certificate. You need to know all the places that you need to try and find, whether there's assets, whether they're 401ks, whether they're savings accounts, etc. So what we would do is that we would basically get an order signed by the judge. Normally it takes anywhere from 3 to 5 days. Once we process it, we will either call you or mail it out. You can pick it up, whatever the case may be. At that point, you would take that limited order to, i.e. Bank of America. You could go to Navy Federal. You could go to Wells Fargo to get information on the mortgage because you may not have that information. And then that's the compiling process of trying to get all your documents together that you don't have, so we can make a determination as far as what type of estate that you have. And that's what is very important with that limited order. But the most important thing is to know where those assets are. And that way we can assist you as far as retrieving those.
So that goes back to putting those papers together.
That's correct.
So that if someone has to handle business for you, that all of those important documents are available. A lot of information, a lot for the citizens to know, a lot of good information. We do want to make sure that people call before you come, and that can help expedite your process. 410-752-5131.
I'm Belinda Conaway, your Register of Wills for Baltimore City. Instead of making your usual New Year's resolutions that fall by the wayside in a few weeks, why not do something that will protect your assets that you've worked so hard for? Write your will today. Be sure to visit us on Facebook at Row Baltimore City or call 410-752-5131. And remember, where there's a will, there's a way.
On this week's edition of the Conaway Chronicle, I want to focus on a very important topic: misinformation. They say we die for our lack of knowledge, and that is why, as an educator, I've chosen to do everything I could to inform the community about the wills and estates process. From the PSAs you see on television and or hear on the radio, or even maybe see on our Facebook page, to our quarterly newsletter and this educational series that we produce weekly. I believe that it is imperative that we understand the process that governs our assets while we are alive, as well as when we pass away. I believe wholeheartedly in the quote coined by the late civil rights leader Malcolm X, who would have turned 92 this week, which states that education is the passport to the future, for tomorrow belongs to those who prepare for it today. So when people tell you that you need to have your will notarized, which isn't true, or the state will take over your estate if you don't have a will, another false rumor, don't just believe what they tell you. Do your own research and find out the facts. Call our offices for any information you may need as it relates to wills and estates. 410 888-752-5131 or go online and find out the answers to your important questions at www.registers.maryland.gov. And remember, where there's a will, there's a way.